wait a few more minutes? Should we wait a few more minutes, or should we start right at 12? Well, good afternoon, everybody. How are you on this beautiful spring day? Welcome to our McDougall Lecture Series event for today. My name is Greg Bowman, as most of you know, and I have the honor of serving as the Dean of the WVU College of Law. And today we are honored to hear from our McDougall visiting scholar for this year, John MacDonald. Before I yield the podium to my faculty colleague Jim Friedberg, who will introduce our speaker for today, I wanted to provide you with some background on the Archibald McDougall Lecture Series on international law. It is an interesting story, and we can learn from it. The College of Law has held this lecture series for nearly 30 years, and we have had McDougall international faculty visitors who have come to us and taught at the College of Law for a number of years as well. So let's go back 30 years to the 1980s, back in the dark ages, when I was in college, but that's another story. Back then, it was not common to talk in U.S. law schools about international law or global affairs. We do it regularly today. We have a concentration in international law at the college today, but back then, it was uncommon. So this lecture series, dating from the 1980s, was quite literally ahead of its time when it was established. It is part of our long tradition at the College of Law of being committed to addressing issues that are important to the global legal community, and we owe a debt to Mr. McDougall for his gift to the College of Law that funds this lecture series. Now, Mr. McDougall's background is fascinating, so let me summarize it for you briefly. He was a lawyer. He lived for many years in Berkeley County in the eastern part of West Virginia, and he embodied West Virginia's ties to the wider world outside the state and outside our nation. But he was not a WVU graduate. He wasn't even originally from West Virginia. But he was a true Renaissance person in every sense of the word. He was born in 1908 in Hobart, Tasmania. He earned his bachelor's degree and law degree from the University of Tasmania. He was a Rhodes Scholar. He was educated at Oxford and Columbia, and for much of his career, he was active in diplomatic affairs. He was a representative to the U.S. Senate's Legislative Counsel's Office. He was a law professor in Iraq. He served as a delegate to the League of Nations, the predecessor to the United Nations. He represented British interests and American interests during World War II. And after the war, he was a legal advisor to the British Embassy in Egypt and the British Foreign Affairs Office. Now, that's all very impressive, but in 1952, Archibald McDougall decided to make his big move, and he moved to West Virginia, where he was a well-known attorney in Berkeley County for many years. He served as president of that county's Bar Association. He was a member of the West Virginia State Bar and the American Bar Association, and he was admitted to the U.S. Supreme Court and to the Middle Temple Bar, one of England's 4 Inns of Court for barristers. In short, Archibald McDougall lived a full and accomplished life. He passed away in 1984, but he bequeathed money to the College of Law that established this lecture series, and his gift ensures that his legacy and international impact live on through our McDougall Lecture Series, and we're proud to be the home of that lecture series. Now, I myself am an international law scholar. My primary area of specialty is in international trade, and let me just say that I firmly believe that addressing global issues is not just a way to better understand the world, it's also a way for us to better understand ourselves and our state. For me, gaining an appreciation of international law as a practitioner and a scholar has helped me become a more compassionate and a better person. It's helped make me a prouder and better citizen of our state, and I think we all owe a debt of gratitude to Archibald McDougall for his lecture series, a lecture that transcends his lifetime as well as the boundaries of our state and our nation. So with that, I will turn over the podium to my colleague and friend Jim Friedberg, who will introduce our speaker. Thank you for being here.
I'm sorry that you have to sit through 2 introductions, but that seems to be the current trend. John MacDonald is truly a participant in history, partly because of choices he's made and partly because of the era that he was born into. He himself represents one trend, a trend toward human rights, a trend toward universalism, a trend toward multiple identities that eschew limited nationalism. At the same time, he is a Scot, a Brit, a citizen of Europe, and through his participation in the work of The Hague, I would have to say he's a citizen of the world. An unfortunate event called Brexit occurred, or a vote occurred, and Brexit is about to occur this year. And he, along with other Scots and Irish and Welsh, might have to choose between 2 of those 4 identities, unless some kind of administrative or legislative miracle occurs. But in any event, that's one of the trends of the last half century, the trend toward being a citizen of the world like John, having multiple identities, having studied and gotten 2 law degrees in Scotland and a degree in European law in which he studied in French on the continent, as well as working with the Gaelic language, which is an inherent part of Scottish nationalism in one of his projects. So he represents that enlightened, humane, multi-layer new man, who I hope is not disappearing. On the other hand, his work at the ICC deals with a counter-trend. With the dissolution of the Soviet Union in the early 1990s, after the fall of the Berlin Wall, and the sort of junior dissolution of the state of Yugoslavia into its component national parts, the trend of angry and violent nationalism re-entered Europe for the first time in half a century since the end of World War II. And the work that John has done with many, many others in The Hague at the Yugoslav Tribunal is a legitimate legal reaction to the excesses of that kind of nationalism. This is historic in a number of ways. It occurred at the fall of the Soviet Union. It occurred at the re-rise of nationalism. It occurred at a time when international courts, particularly international criminal courts, regained legitimacy for the first time in 40 years after the Nuremberg trials. That legitimacy had been stalled by the Cold War, but with the end of the Cold War, it was again possible for this universal enforcement of human rights to be done by international tribunals, with the Yugoslav one enabled by the UN Security Council being the first among them. Another historic event of a substantive nature is that it was quickly recognized when the world was going to re-enter this era of international criminal prosecution for major human rights wrongs, that the old Nuremberg rules, which were laudable for their time, dealing with crimes against peace, war crimes, and crimes against humanity, were deficient in one major respect. They didn't deal with sexual violence, which has been used as a horrific tool of war for thousands of years. John is going to be speaking on the topic of integrating that kind of crime into the notion of crimes against humanity that was first brought up in the modern era in Nuremberg. So both as a scholar and an example of modern humane universalism, it is fortunate for us to have John MacDonald speaking to us today.
Good afternoon, everyone. As the two speakers have already said, my name is John MacDonald, and I'm going to start with an apology, which is you need to sit through introduction number 3 now as well. One thing I always say whenever I speak to students not from Scotland or I speak abroad is I am told that I have a Scottish accent. I don't hear it myself. If people cannot understand me, then all I can really do is apologize and try to speak more slowly, but I will endeavor to do that. So let me start by saying thank you for that kind introduction, very kind introduction. I've never been described in such glowing terms, to be honest. And to say thank you as well to the law school here for giving me the opportunity to come, to teach and to discuss an issue that's very close to my heart, which is international criminal law. There are some links between West Virginia University School of Law and the Tribunal for the former Yugoslavia, where I worked for about 5 years. 2 students from this law school came as interns or externs, however you want to describe it. Meg Starnes and Katie Wilson. I had the pleasure of working with them as their direct supervisor, and they both excelled in the tasks asked of them and made a very positive impact at the Yugoslavian tribunal. So there are those links. And it's also perhaps fitting that a person who worked at the former Yugoslavia, a body created by the United Nations, gives the Archibald McDougall lecture, given that he himself worked for the League of Nations, the precursor to the United Nations. Having said all of that, the last thing I want to say is, in the introduction, if anybody is interested in the topic I'm about to discuss, and I think it is quite an interesting and in some ways shocking topic, the ICTY, the Tribunal for the Former Yugoslavia, recently published a book called Prosecuting Conflict-Related Sexual Violence at the ICTY. And it delves in far greater detail than I can into this topic. I worked with the contributors to that book, and this talk is in fact a combination of my own experience and the themes in that book. Moving on to the topic itself, the first thing I'd like to explain is why I chose prosecuting sexual violence as the topic of this talk. And really, it was for 3 reasons. Firstly, as Professor Friedberg noted, sexual violence is ubiquitous to armed conflict and to situations involving a widespread or systematic attack against a civilian population. It happens all the time. It has happened all the time. And in fact, it used to be the case that military leaders would promise their soldiers, in essence, license to do whatever they wanted with a defeated enemy civilian population. So if you're sieging a town, one way to keep your soldiers enthusiastic to take that town is to give them license to rape when the town falls. And the second reason is that sexual violence is a uniquely destructive crime. It has the 2 components, sexual and violence. And the impact it makes upon individuals and upon groups is quite devastating. There is the physical impact, of course. It is a generally brutal act of physical violence directed against an individual. But there's also and in many cases, more severe emotional and mental damage in the long term. And so holding those two ideas together, the third reason is there has been this shift in how we approach sexual violence. And I think it's very important to know where we began, where we stand now, and where we might end up in the future. I'm sure everybody knows these words from George Santayana. Those who cannot remember the past are doomed to repeat it. I can't really see the, the PowerPoint from down here, but I'm assuming that's moved on. This is a legal lecture, so of course there has to be an argument about definition. The first thing I'm going to say is I'm going to restrict my comments to rape, perhaps the best known crime of sexual violence. That's to some extent for a matter of time, but also because in looking at the evolution of rape, or the approach to prosecuting rape, it really mirrors the approach to prosecuting sexual violence in general. So rape is largely emblematic of sexual violence. I don't think we will miss anything by concentrating on rape. So this definition that I'm about to show, it comes from the International Criminal Court. The International Criminal Court was established in 1998 by the Rome Statute. And it really signifies, I think, where we stand now. So there we have: the perpetrator invaded the body of a person by conduct resulting in penetration, however slight, of any part of the body of the victim or of the perpetrator with a sexual organ, or of the anal or genital opening of the victim with any object or any other part of the body. I'd like to highlight two things about this definition. The first, it is very, very broad. It covers the classic rape situation of a man raping a woman, but it also covers rape with an object and digital rape as well. And the second thing to highlight is it is gender neutral. This word, invaded, the third word of the definition, there is a footnote to this in the Rome Statute, which I have omitted here. But it specifies that the word invaded was chosen precisely because it is gender neutral. And one thing to be very clear about is this reflects the experience of the Yugoslavian tribunal and of the Rwandan tribunal in trying to prosecute these crimes. It's I think, a very progressive definition. But it is important to understand that this is not how we began. This is the point after 43 years of refinement, after the Nuremberg Tribunal was first set up. And what I'd like to do is move through the approach towards prosecuting sexual violence, which I categorize into three different approaches. With regard to the first approach, international criminal law, as we understand it today, really only came into existence in 1945, after the Second World War. The Second World War was the single most bloody conflict known to humanity. It involved somewhere between 50 and 85 million fatalities, and it involved countries all around the world. At the end of the Second World War, there was a determination, spearheaded, in fact, by the United States of America, to hold the Nazis accountable and the Japanese leaders accountable for what took place, for both starting the Second World War and the crimes that happened during it. And so the Nuremberg Tribunal was created. And that's what the Nuremberg Tribunal did. It found the Nazis, convicted them, held them accountable for a whole host of crimes, including crimes against peace, mass extermination, destruction of property, torture. But amidst all of this, no conviction for sexual violence for anyone. And why was this? Well, if you look at the charter of the Nuremberg Tribunal, the London Charter, you will not find any explicit mention of sexual crimes. Equally, the French prosecutor, when he submitted his dossier detailing the crimes of the Nazis, asked for forgiveness if he didn't detail all the atrocities that had been committed. In essence, he did not lead evidence of sexual violence crimes. So really, I think that this first approach can be summed up as viewing sexual violence as the invisible crime. We had moved on slightly from allowing sexual violence to happen to encouraging soldiers by allowing sexual violence, but we were not yet at the stage of prohibiting it and prosecuting it. Unfortunately, Nuremberg, which did many, many good things, I don't wish to leave you with the impression that Nuremberg was a fully flawed tribunal. Nuremberg was the end of this first approach, this approach that had lasted throughout history. Nuremberg was really the end of that. And we moved into the second approach with the Tokyo Tribunal. The Tokyo Tribunal was the counterpart of the Nuremberg Tribunal, set up in the Far East to try Japanese leaders. And what they were faced with was a huge crime committed in 1937, the so-called Rape of Nanking. For those who are not aware, Nanking fell to Japanese soldiers, and in the following 7 weeks, they slaughtered anywhere between 200,000 and 300,000 inhabitants. And Japanese soldiers raped anywhere between 20 and 80,000 women and children, as young as 10 and as old as 80. And faced with that kind of mass criminality, there were convictions entered for sexual violence by the Tokyo Tribunal. But they were all linked to other crimes, crimes like persecution. Sexual violence didn't stand on its own. And the other very famous aspect of the Far East theatre, the so-called comfort stations. Again, for those who don't know, approximately 200,000 non-Japanese women were abducted and made to travel around with the army so that Japanese soldiers could satisfy any sexual desires whenever they wanted. Those were overlooked by the Tokyo Tribunal. And so this second approach, I see it as looking at sexual violence as either a sexual crime or a violent crime. And the reason I distinguish between them is because the law distinguished between them. It divided sexual violence based along the gender of the victim. So the prosecution, the approach to prosecuting sexual violence depended if it was a female victim or a male victim. For female victims, which I'll discuss first, and before I do though, there has been a misconception that sexual violence in these situations is only committed against females. While females certainly bear the brunt of sexual violence, the majority of the crimes are committed against them, there are a substantial number of sexual violence crimes committed against males. And I've had the misfortune, truly, of dealing with the evidence and testimony of male victims talking about what certainly amounts to rape in conflict. Speaking about female victims first, well, here in the second approach, the notion of sexual violence crimes was linked to notions of female sexual purity, of honor, innocence, dignity. These were the values that were seen to have been attacked by sexual violence crimes. And it seems like quite a strong accusation, but let me show you some of the treaties agreed at the time. The first one we're going to look at is one of the Geneva Conventions, Geneva Convention 4. For those, again, who are not entirely au fait with that set of treaties, it's a set of treaties that prohibits certain state behavior in an armed conflict. It protects certain categories of people, in this case civilians. So here is sexual violence under the Geneva Conventions. Is there anybody who can't see that from where they're sitting? Okay, thank you for the thumbs up at the back. That's great. So I've bolded a couple of parts that jumped out at me. I'm sure they jumped out at you as well. Women, so there's your gender divide, shall be especially protected against any attack on their honor, in particular against rape. So this is 1949. But the Geneva Conventions, they are almost universally ratified. They have entered the status of customary international law. Fast forwarding to approximately 30 years to the so-called additional protocols. These built upon the Geneva Conventions. They tried to make the Geneva Conventions more relevant to the warfare of the day, which had switched from traditional state warfare to guerrilla warfare. So this one deals with non-international armed conflict. And here is how it deals with sexual violence crimes. Outrages upon personal dignity. Any form of indecent assault. Now, you may well argue, and you would be right, that this is about state behavior, not about individual behavior, and it was many, many, many years ago. But fast forwarding again, the ICTY and the ICTR statutes. So I worked for the ICTY, that is the tribunal for the former Yugoslavia. The ICTR is the International Criminal Tribunal for Rwanda, set up following the Rwandan genocide in the middle of 1994. The ICTY statute was adopted by the United Nations Security Council in 1993. So the most powerful body in terms of international politics and law, charged with maintaining international peace and security. No mention of sexual violence as a war crime. The Rwandan statute, 1 year later, it mentions it certainly, but it repeats this language from 1977. An outrage upon personal dignity, specifying that's what rape is. So this is what I mean by this talk might seem a little shocking, because these notions are incredibly outdated now. Now, you may well say that at least we have progressed from no prosecution at all to some form of prosecution. But there are problems with this approach, really pervasive problems. The first, you devalue the severity of the crime. Sexual violence involves a brutal attack of physical violence, first and foremost. If you view it solely as an attack upon someone's honor, you miss that component. You miss that severity. And the second issue, and for this I need to step back a bit and explain how international criminal prosecutions normally work. International criminal prosecutors normally face the following situation. An army has taken over a territory, and they have made that territory ethnically or nationally or religiously pure. So they have driven out everybody who is not a member of their group. Now, I hope no one here has tried to do that, but it is very, very hard, if not impossible, to drive people out in a non-violent way. And let me give you an example. If I said to all of you today I will pay double the value of your home and possessions if you will leave Morgantown, go to Canada, and never come back. Now maybe in today's climate, that might be an attractive offer to some people. No, okay. But I'm sure many of you would in the end say, no, the United States of America is my home. West Virginia is my home, Morgantown is my home. I will not leave my country. I will not leave my roots. I will not leave where my family has been buried. So really, to conduct ethnic cleansing campaigns, you require force. But the second issue is, it's very hard to murder everybody. Just as a practical matter, not even talking about it morally, it's hard to murder, torture, steal from everybody, everywhere. So the tried and tested method is creating an atmosphere of terror, so that when you come to the time of moving people out, or providing the buses to move them, the population actively wants to leave. That is how you conduct an ethnic cleansing campaign. And the way that you create an atmosphere of terror is quite straightforward. You murder a family here, you murder a family there. You steal all the possessions of the ethnicity or nationality that you're targeting, even the ones they need to survive. You torture them, disappear some, destroy buildings that are important to them, churches, cultural buildings. And you use the very people that are meant to protect them to do this. Primarily the police, sometimes the army. You make them feel vulnerable, powerless, terrified. And so all of those crimes you can see as being intended to create this atmosphere. But the problem with sexual violence crimes, to go back to that, is if you view sexual violence as essentially done for sexual motive, you view it as an individualistic crime. So Army A takes over Village B, they separate the men, beat them up, put them in camps, they forcibly transfer the women, expelling them, and when they do so, some soldiers, they're drunk, they're victorious, the women are vulnerable. Sexual violence, it just happens. If you view it in that way, as a spontaneous crime, then there is an impossibility of locating sexual violence as part and parcel of a campaign of ethnic cleansing. And you get this very unfortunate result where a lot of crimes are intended: murder, theft, destruction, torture, all intended. But sexual violence, at most that can be seen as just foreseeable. And that is all. So these are problems that flow from this faulty paradigm. I've spoken about female victims, but what about male victims? Well, again, if you come from the paradigm that a man raping a woman is only ever done to satisfy sexual urges from a sexual motive, then when you try to classify a man, or indeed a woman, raping another man, then, to put it crudely, you decide that this is a crime without a sexual component. Of course it's not done to satisfy any kind of sexual desire. It must be done for power. It must be done for violent means. And so this is the conclusion you get. Sexual violence against males is a crime purely of violence. And that too leads to problems. Because again, while it's easier to locate it in an ethnic cleansing campaign, you again massively devalue the crime. To show you how true this is, I'll tell you something that's happened to me. I have spoken, or I've seen speaking, male victims of sexual violence. And I've seen many men talk about being, for example, imprisoned in a camp. And they talk about beatings and starvation and terrible psychological crimes like mock executions. And many of them speak about it with a certain badge of pride. I was held by our enemies for months on end, starved, beaten, tortured, and I am still here. I am still standing. I survived in spite of that. I've never come across, nor seen, nor heard of any man who ever speaks in the same way about sexual violence. Because it is such an attack upon the masculinity of a man. It is aimed at the emasculation of male victims. But you lose that if you look at it as purely a crime of violence. But I'm happy to say that during the lifetime of the ICTY, so the ICTY was created in 1995, and it's still prosecuting today. We evolved in our approach towards sexual violence. You're going to recognize the next phrase when it comes up, I'm sure. Rape as a weapon of war. I'd rephrase it slightly to say sexual violence is a weapon of war, because sexual violence is wider than rape. But it is now recognized that sexual violence crimes are part and parcel of these campaigns to ethnically cleanse. As Professor Friedberg mentioned, the last 2.5 years I've been a prosecuting trial attorney on the case against this man, General Ratko Mladic, commander of the Bosnian Serb army during the entire civil war in Bosnia, which lasted just over 4.5 years. He is charged with war crimes, crimes against humanity, and genocide, the full range of crimes available to us, for ethnic cleansing that took place in 1992, for the siege of Sarajevo, one of the most brutal modern sieges known to man, and for genocide, for what took place in Srebrenica in July 1995, when approximately 7,000 or 8,000 men were executed across 4 days. And I am certainly proud that as a member of that team, we charged and fully argued sexual violence crimes as I think they're meant to be charged and argued. That is, regardless of gender, first and foremost, this brutal act of physical violence that takes a massive mental and emotional toll. This trial finished after 4.5 years in December 2016, and the judgment is currently scheduled for November 17 this year. Now, I don't wish to make this any kind of Hollywood talk, where we had a problem, we resolved it through some kind of great feat of strength, and now we all live happily ever after. Problems remain in the approach to prosecuting sexual violence. They range from the practical, to give a couple of examples. Getting people to talk about sexual violence that has been inflicted upon them is incredibly hard. Many times in hindsight it sounds obvious, but if you're an investigator and you interview women and children, and some men, and they talk to you about, yes, my village was taken over. Yes, the men were separated off. Yes, they were beaten. Some were taken away. We heard shots. We've never seen them again. And then the rest of us, the men were taken to camps. Some of them have been exchanged. The rest of us were forcibly transferred over the border. You have a whole range of criminality there to pick from. You have murder, you have torture, forcible transfer, theft. You have a whole range, a whole spectrum. What you might not realize in the 20 or 30 or 40 witness statements you get, all telling this story, is that when the men were separated off, that means the women were separated as well. And quite often, in that time period, the women will have been subject to sexual violence. That's certainly the experience that we had in the former Yugoslavia. But they won't talk about it. They'll happily talk about other crimes. But it takes a lot to get them to talk about that. A second practical issue, what's called witness fatigue. This applies, I suppose, to any crime, but particularly to sexual violence crimes. Imagine that you are a victim of sexual violence. And when you first escape the country, you get interviewed by an NGO. and then 2 or 3 more NGOs across the next couple of years. 5 years later, you get interviewed 2 or 3 times by investigators from the Office of the Prosecutor of a tribunal that's been set up. And then a couple of years after that, you get interviewed by the defense. And then finally, you come to trial, maybe 15 years later, to talk about events you're now desperately trying to forget. You're subject, of course, to cross-examination. Imagine that scenario, and then imagine having to testify 2 or 3 times more in different cases. And you will know what certain victims of sexual violence went through at the Yugoslavian tribunal. From the very best of intentions, but nevertheless. One other problem I wanted to highlight is still a conceptual one, and it's this. In order to truly reflect the damage done by these crimes, you have to look at the stereotypes held by the community in question. So a male or female victim of sexual violence might be rejected from their community because, a man is no longer seen as a man, or a woman is now seen as damaged goods, or phrases to that effect. How do you prosecute and bring out that level of damage without reinforcing the gender stereotypes that it's based upon? And that is a real issue that faced the ICTY and will continue to face institutions like the ICC. But to finish, the positive for me is I believe we've now moved to what can be described as the correct approach, the correct basis for prosecuting sexual violence crimes. And again, I think it's so important because on the one hand, you properly categorize this crime and you properly recognize how serious it is, the destruction done to individuals. To give an example of that destruction, the ICTY has recognized that rape can constitute genocide in certain circumstances. That might strike you as odd if you're used to thinking about genocide as the Holocaust or the Rwandan genocide, 800,000 people murdered by machetes in 100 days. But when you see the testimony of these victims and you realize many of them testify that they are dead inside, that they have been killed psychologically, it stops them from leading a normal life. It stops them from participating in the reconstitution of their group. And so rape, when it's committed with this intent to destroy the group, to destroy the person, can constitute genocide. And recognizing things like that, recognizing the severity of the crime, I think is so important in giving some solace, whatever solace can be given, to the victims. A second thing it does is it solves this issue of locating sexual violence in ethnic cleansing campaigns. Ratko Mladic, the guy I showed you on the screen, I fully believe that when he used his army to create this ethnically pure area that he wanted, he meant for it to commit all those crimes against the other ethnicities: murder, theft, destruction, torture, also sexual violence. And finally, of course, I think it's true to say that justice is better done when you properly categorize the crime and the harm that has occurred. So, for all those reasons, I think we're now in a better place than we were. That's me. Thank you all for listening.
We do have time for questions and a mic, if anyone would like to ask any questions or make comments.
First, I would like to thank you for what you do. I mean, it's wonderful. Second, I'd like to apologize for my attire today. As the mother of 3, I'm lucky to get out of bed sometimes and get to law school. One of the biggest concerns for me, I have 3 children who have a very rare genetic syndrome, and it's caused them to have intellectual disabilities. And I've seen in the U.S. how devalued individuals with disabilities are in society, period. Here, and I'm sure that's that way across the globe. So a big concern for me is the steps that are being taken to actually focus on is there anything being done to get some education out there to protect people who have disabilities? Because they are extremely vulnerable to these types of acts. So,
But I'm happy to say that the answer, to a large extent, is yes. It's now recognised, and it wasn't really at the start, but it's now recognised how important it is to reach out to the communities affected by these crimes, and also to use these terrible situations as in effect a warning with regard to other communities about what can happen. It takes place on a national and community level, so it's hard to summarise the extent of these things, but definitely steps in that direction. And actually, perhaps as a more concrete example, the ICC definition, which I showed you earlier, it goes on to talk about how the act in question is procured, and it uses the concept of force. It says force, the threat of force, taking advantage of a coercive environment, but also it can be constituted when it's done to people who cannot give consent. And so that portion of the population which for some reason or another cannot give genuine consent is absolutely protected by this provision.
Thank you so much for being here and speaking to us, and thank you for the work that you're doing. I've learned a lot from this. I don't know anything about it, so this may be a stupid question, but two things I'd be curious to hear more about. One is the question of what alternatives would there have been to trying somebody like Radish in some court other than your court? Like, how does it come to be that is seen as the preferred venue? And obviously this is something you know everything about, so it might be interesting to hear a little bit more about that. And also, a 4.5-year trial is a fairly remarkable thing, and I would be interested to hear more about kind of what goes on a day-to-day basis in a trial like that. I mean, is it a matter of there's extensive cross on everything, or is it simply a matter that the sheer volume of evidence to be brought to bear in a case like this is so overwhelming that it simply takes that long to put it all on? So I mean, I think I hopefully those would be two things of interest to people.
Well, with regard to really alternative methods of prosecution or alternatives to prosecution, there are ideas out there. For example, South Africa had the famous Truth and Reconciliation Commission, and in certain circumstances people argue those are more appropriate, and really I think that comes down to a subjective approach that one takes. There's other less palatable solutions that are found, things like amnesties, although these are generally looked on with quite a lot of disfavour in international law. In setting up the International Criminal Court, the hope was that it would be able to either take the situation to The Hague or take, in a way, the court to the situation. And therefore you wouldn't have all these expensive and very slow, as you've noted, ad hoc tribunals. But outside of those methods, I'm not really aware of any other methods that are used. And actually, the ICC has not covered itself in glory over the first years of its operation. And while it's recovering, for example, in Syria, from what I understand, the talk is of a separate tribunal rather than referring that to the ICC. So that's with regard to the first question. With regard to the second one, it is a mix, really, of the two solutions that you mentioned. The first is that we certainly answer this question a lot. If you think of a normal criminal trial, then you're talking about, let's say, an assault. It normally lasts 2 to 3 minutes, a bit of argument, a bit of punching, and then people are separated. And you're maybe calling 2, potentially 3 witnesses for prosecution. The defense doesn't call anyone, and the judge decides, or the jury decides. Those still take a day or a day and a half to prosecute for whatever reason. In essence, the volume of criminality that we deal with is just astounding. When you prosecute a war, we called something like 220 witnesses, I think. I think the defence called, they certainly called more than us. I think they may have called up to 300 witnesses in their case. We put in 7,800 exhibits. The defence put in maybe 2,000 to 3,000. It's just a vast, vast volume of material. And if you think about it, if one assault takes 1 day to prosecute, what we're prosecuting is a war that lasts 4.5 years, right across a country, and involves thousands upon tens of thousands of criminal incidents, to the point where in all of the more recent trials, the prosecution has been ordered to cut down its indictment, to take out things we think are criminal that we can prove, because there's just so many of them. So that's really why there's, of course, administrative difficulties. We have to translate simultaneously into various languages. The time given between sections of the case tends to be quite long, and the courts have been criticised for that. At the end of the prosecution case, before the defence of before the start of the defence case, there can be 2 or 3 months that elapse. But generally, I think it's a combination of what you proposed, and yeah, efforts are always made to slim down trials, but this is how long trials run. I think international criminal justice is just a slow business, to be perfectly honest.
Was there any form of because it was such a horrible crime and did go on for 4 years, so was there any form of a rehabilitation offered or an advocacy program in place for victims, or was there just such a large number and it was just so diverse that it wasn't possible?
Not so much at the international level. The International Criminal Tribunal for the former Yugoslavia and the Rwandan Tribunal, they followed very much the common law adversarial approach, whereby, unfortunately, victims are seen as witnesses and as exhibits, pretty much, and not much else. On a community level, on a national level, there certainly is, there always is, and the UN often reaches out to try to help with these things, funds for victims, retraining. Rehabilitation can be very, very hard, particularly when, as is quite common, sometimes communities, they don't prosecute their own. One of the reasons why ethnic cleansing is so permanent is because it's not just a question of moving back to a hostile atmosphere in your previous community. It's a question of walking around when the person who inflicted all the violence upon you is also just walking around, not having been touched. So rehabilitation founders to some extent on basically, no conviction, no admission of guilt. The ICC, I'm happy to say, is a bit more advanced in this regard. It takes more from the civil law system, which not only establishes a fund for victims to which they can apply, kind of like a civil lawsuit, but also victims can become parties to the case, so they can get their own lawyer and have them ask questions of the various accused or witnesses. So I think that helps to some extent. But in general, I would say we're very much at the start of that process, and victims are not best taken care of all the time in international criminal tribunals.
We're out of time. Let's have another round of applause and thanks. Appreciate you being here. Some of you have class, so enjoy the rest of the day. Thank you. That's great. Really good. I'm glad to be here. And they can see the screen fine.